parties want it. Did I lose Mr. Dickerson? Where's? Oh, okay, I'm sorry. Yeah, you can come down and sit at council table with your attorney.
Oh, there it is. Thank you.
Okay, that's okay.
And policy may have changed. Can I have one hand free so I can actually make some
It's
notes?
up to the CO.
CO? Can I have one hand free, CO?
I cannot do it with one hand, I have to bring my sergeant up here.
Okay, well, we're just gonna, it's okay. We're just gonna proceed. If the parties will make their appearances.
We need to
Mike
consult with
Dickerson on behalf
counsel
of the state,
first.
Your Honor, bar number 13476.
Morning, Your Honor. Joseph Gerson, 13876 for Mr. Blandino, who is at my left in custody.
Okay, and it's my understanding you wanted to call your client again to get further.
No, Your Honor. I do not want to call my client. I have advised him that I do not believe it is in his best interest to testify. It is against my advice. Also, as I believe from the last hearing, Your Honor, I do not believe that I can question him for various reasons, so he would have to testify in the narrative.
Okay,
I'd also like to let the court know that I have had conversations with Mr. Blandino about trying to stay on point and relevant, and I will do my absolute best to keep him there, but we've been here before.
I don't know when that conversation was.
okay.
when
Well, I appreciate that. So, Mr. Blandino, did you want to testify further?
Yes.
And it's something new. You're not just gonna
It will
repeat
be,
everything,
it will be in
correct?
part to rebut what Mr.
Perfect. If
I
you'll
mean,
raise your right
Officer
hand,
Chandler.
so you can be
Again, I
sworn.
can't raise the hand, but I can state under.
That's
penalty
right.
of
Okay,
perjury.
you understand you're gonna be testifying under the pains and penalties of perjury.
And I have to tell the truth, the whole truth,
Right.
and nothing but the truth, and I could be prosecuted for perjury if I don't.
Okay, go ahead.
Okay, I need that probation violation report. Thanks.
May I approach, Your Honor? He's looking for the probation the violation report that I gave you, or the thing you
Both,
didn't
I
sign?
need both the violation report and the one that didn't.
You have the
he said
violation
chose to
report.
sign.
I gave you a copy of that.
They brought me up by surprise here and I didn't collect it. For
How could it
myself.
be by surprise? You knew we had a hearing today.
No, they told me last night that it's rescheduled to Tuesday. And they told me that as late as yesterday.
Okay,
I thought maybe it was because of the holidays. And then they surprised me by bringing me up. So I heard
By
what you
court's
said.
indulgence, Your Honor, I'm just have to
And
find
Your Honor,
it.
to that point, the probation violation report is not in evidence, so unless there's some basis for him to have that.
I will print him out a copy so he can have it.
Yeah, and I don't know why he would need it from while he testifies.
Well, I need those conditions and stuff as well, whatever that was, where the conditions were, where it says chose not to sign,
Okay,
what do you
hold on
call
one
that?
second. If I may approach, Your Honor, I'd like to get Defendant's Exhibit A.
Sure.
That was the probation conditions.
Please make sure not to mix up papers.
Yeah, we just gotta make sure we get that back.
Yes, yes. And again, court's indulgence, I'm just trying to find the violation report. I am trying to get the violation report.
I'm
Please let
gonna
me do that.
copy it right now for him.
I'm gonna find it for you so you
Mr.
can have
Gerson,
it.
if you wanna approach.
Thank you, Your Honor.
Okay.
Thank you.
Okay, go ahead, Mr. Blandino.
Well, the reason why I wanted this probation report is that they've got non-technical stuff on here. This was done in September 2022, and I did go to that mental health evaluation as required, paid them the fees. On the very day I was arrested at 3:15, they did it, and Officer Duque did admit over the phone when I called her that the report was done, the mental evaluation report was done, and that I did not need any further counseling. So this charging document, and I presume it's a charging document, is not current. I want to note that it still says I
Who
have,
did the evaluation? Who did the evaluation?
ABC therapy over there in Eastern. They charged $123, which I had no idea when the sentencing was done I was have to pay for that. Nor the ankle bracelet that they charged $12 a day for a month. And that's not on this report. But you'll note that this 297 days per the PSI is still on there. It was stipulated in court that I was 134 days credit time served. So I'm tying this into the testimony to rebut what Eric Chandler said. It was indeed truthful what he said. There was a long conversation. This document, he went over, we went in person on the parole and probation office over there on Bonanza and whatever that cross street is. And there was indeed a long conversation. And I said, look, there's no way I can sign this because I can't understand it. If I say that I understand something and sign something, that would be a lie, and if it's filed into court, I could be charged with perjury for that. Each of these conditions, these special conditions, I understand subject to be placed on intensive supervision for a time, and I did do the 1 month with the Scram people. It's a private subcontract to that organization. I still owe them some money for the ankle bracelet. Have no direct or indirect contact with the victims in this matter. So according to that, I understand that that's Federico and Mr. Marwitz, according to the charging document and what was presented in court. Marwitz was claiming to be a victim. Not to file any documents unless consistent with the vexatious litigant order. Do you have that order? There was an order filed by Judge Bell that modified the vexatious litigant order and allowed me to do the probate on my mom's estate. She's dead. And she modified the vexatious litigant order. So I couldn't sign for that because it should say consistent with the vexatious litigant order and the modification order issued by Judge Bell. I got a certified copy. I gave it to counsel, and he can't find it at present. So that is not correct. It should have been unless consistent with the vexatious litigant order and the modification order listed by then Chief Judge Bell. Not to file any fugitive documents. This now, on its face, Eric Chandler did not know, Officer Chandler, he did not know what a fugitive document was. And I, frankly, do not fully know what it is. My notice of appeal is the only reason why I have an appeal pending. That was filed because counsel wasn't even aware that an appeal can be taken from the verdict under Witter versus State and under the statute. You can either appeal the verdict or the judgment of conviction. I'd like the record to show that Mr. Gersten did not file any notice of appeal of this judgment of conviction. Therefore, the time has passed. It would be late. So was my notice of appeal a fugitive document? Was my motion for a new trial motion a fugitive document? In the Nevada Supreme Court, even though they force counsel on me, they allow in their rules, the Nevada Rules of Appellate Procedure, for me to file a motion to remove counsel. That is specifically allowed. Now, do I have that right to file a motion? I couldn't risk the chance that I would be violated on probation. So that is not an understandable order. I could not understand. I would need a definition of what this court meant by fugitive documents in order to sign that. I undergo the mental health evaluation and complete any counseling deemed. I did that. Have no contact with Mr. F at all. That's, I'm presuming it's Federico. That's true. I haven't. Defendant may contact Mr. F's attorney only for legal matters. That's understandable. Clause 6. Submit to a full financial disclosure to parole probation as deemed appropriate. As of yet, they haven't asked for it. They haven't deemed it appropriate. Have no contact with the courts. Now, this is brilliant. And this is absolutely brilliant. I already have contact with the U.S. District Court. I have 2 lawsuits going, one against Mr. Federico and one against LVMPD and other DOE defendants. I have contact with the U.S. Supreme Court. This is crazy to think that I could understand no contact with the courts. I can't have contact with the North Las Vegas court. I have a thing that I need to get addressed there where they dismiss the ticket without prejudice, and I want to change that to with prejudice. It's about 3 years old now on a no prosecute. I have the right to, this order is in fact illegal with these special conditions. It's an illegal sentence. In fact, the judgment of conviction is illegal under all the case law, and 176.555, you can correct an illegal sentence at any time by motion. Now, what makes it illegal is the 134 days that the district attorney admitted that I had credit on that sentencing day is not in the judgment of conviction. I'm entitled to that by law, by case law, by statute, in every way. And to see this reflected in the parole and probation giving me much more time than the 134 days, and that's what I was given in the PSI report. I beg counsel to say, you need to put in a motion to correct the PSI report. You saw me stand here and say that 297 was not correct at sentencing day, and it needed to be corrected, because I don't want to be charged with trying to receive good time credits I'm not entitled to and possibly criminally prosecuted for trying to accept something fraudulently. I believe in the truth. I'm testifying to the truth now. So your sentence, Judge, was illegal on that day. It's illegal as to these conditions. I am not supposed to be able to, required to guess what you meant by these conditions. Now, I have to note that the conditions you gave me to stay away from the RJC, and later on, because the city court moved from this building to their own building, later on it was asked by Mr. Dickerson and granted by this court pre-sentencing that I stay away from the city of Las Vegas municipal courts. That's understandable, but I go to the Nevada Supreme Court and the federal courts all the time. Sometimes I go to the Nevada Supreme Court just to say hi to the bailiffs and marshals because they're nice guys there. As a matter of fact, I went for oral argument to the Nevada Supreme Court in the case of Marlon Brown versus the warden, in which you were the the judge in the underlying criminal case. In that case, Marlon Brown, which is now on appeal on the denial of the habeas corpus writ. Do not enter the courts unless the defendant is present for official business. Now, this is completely rich. I was prosecuted for claiming to be an official. I can't do any official business because I'm not an official. I'm an unofficial investigator for the commission or with the commission on judicial discipline. Unofficial. So what the heck do you mean by official business? Do not enter the courts unless the defendant is present for official business. I'm not an official. I call the clerks when I see a mistake or a problem. So this actual hearing, the probation revocation hearing, is completely out of order because the sentence was illegal. I'm entitled to a new sentencing hearing and a new sentence. There's another reason why this is wrong. I was not given full disclosure. At no time at sentencing was I told that there would be a charge for the ankle bracelet on parole and probation and that I would have to pay for the mental health counseling. As you know, there's a recent case law, Judge, that I am entitled, if I choose to reject probation and to take the sentence. I am not required to take probation. I begged Mr. Gersten and Bateman before we came to the sentencing hearing to put in a motion for bail pending appeal if I get sentenced, if not, for a stay of probation.
Your Honor,
There
may I
was
ask
a
for a step?
motion for stay of probation filed,
Huh?
and it was denied.
Yeah, but it was filed too late. It was denied on the basis you didn't have the power to grant it because it was already on appeal.
May I ask for a sidebar for just 2 seconds?
Sure.
I apologize.
Listen, it's my experience to just let him talk.
Okay.
Because if you engage him at all,
I don't want to.
it'll go 50 different sideways.
My concern is, obviously, I've asked to withdraw. That's been denied. He's essentially saying things that are not true about me. And I find it problematic. If you're telling me just let him go, that's fine, but I'm having an issue with, he's saying, I told him to do this, I told him to do that.
He's saying stuff that isn't relevant as to what he contended he was going to testify to. He's trying to start over.
Okay.
So
I just
I'll redirect him, but
Okay,
generally, if you start asking asking him questions.
I don't want to do that.
You know, I just want
But my honor, if you will, is being assailed, so, okay.
You're good.
Okay, thank you, Your Honor.
All right, Mr. Blandino, I would just ask and direct you to speak specifically regarding the issue that you asked to be heard on, because you have already testified. So anything further?
I'm trying to rebut in total and to present what I told Eric Chandler, and this is very important, this, with what, the conversation that we had, because it was an extensive one. And like I said, he sat in front of me with this form and told me, if he would have said, Mr. Blandino, you're gonna have to sign, or we're gonna violate your probation or make a report, whatever. He was comfortable, he said, chose not to sign, he used that language.
Okay, that's already been testified
Okay.
to. So
Anyway,
again,
I
I
wanna
ask you
confirm that, but I
to
want-
get to the point,
I had
a
to
new
tell him-
point,
I had to tell
not
him-
repetitive testimony.
I had to tell him that, and I told him that that sentence was illegal, these conditions were illegal, they weren't
You've
understandable.
said that now about 3 times, so I'd
That-
ask you to move on to something new.
I said that this judge herself was on probation because the Commission on Judicial Discipline called her, that they lied to her, and that you admitted to violating Rita Donson's rights, that I was investigating you for some time, that this conviction would not
Anything
stand.
further regarding this case?
It does
Okay,
regard this
all right,
case.
okay, I'm
That you
gonna
refuse
assume
to
that he's
disqualify
done.
yourself.
I'm
And
gonna
now
assume
you,
that
Judge,
he's done.
you are now committing
I'm
a crime.
assuming that he's done.
You are committing a
So,
crime under
you're done.
197,
I
2.20.
mean, this is like, this is absurd. Okay, so he is done. Does the state or the defense have any further witnesses? I mean, you're not gonna turn this into a circus.
Nothing further from the defense, Your
Mr.
Honor. We rest.
Dickerson?
Mostly from the state, Your Honor.
All right, I'll hear from the state.
Thank you. Your Honor, we are asking that Mr. Blandino's probation be revoked. Currently, as he sits here today, we're showing that he has 342 days credit for time served. That is not counting today, because of course, if his probation gets revoked today, today will count as the day that his sentence starts. That means as well that he is looking at a 12 to 121 sentence in the Nevada Department of Corrections. In 23 days, he will be eligible to go before the parole board. 23 days. It's time to put this to an end. It's clear what's happened here. It's clear that Mr. Blandino is just up to the same thing he's always been up to. Here in this particular instance, he's indicated that essentially he didn't agree with the terms of probation as you laid them out at the time of sentencing on July 7th, when he was present at the time and heard your rendition of sentence and heard all those conditions of probation. And so he didn't sign his probation agreement. In further, we go into what occurred thereafter, where the defendant comes before this court now, having been arrested on a new felony offense. He admits to Your Honor that those 2 passports that he has, those are his passports. He admits that those are also his driver's license, his international driver's license, as he called it. He admits that he used those dozens of times. He has authenticated the documents that were contained within there, which show that he faxed that same, one of those same passport, fake driver's license, to the Boulder City Municipal Court as it was used by him at that time in the 90s as a driver's license. He admits that he was doing that same thing during the traffic stop in this case on September 16, 2022, attempting to use those passports as his driver's license. He further admits that he even showed the officer, Officer Martinez, that passport. He then tells the detectives who arrived, yeah, those are my international driver's license. That's my driver's license. Under NRS 205.465, subsection 1, it's unlawful for a person to possess any document or personal identifying information for the purpose of establishing a false status or a false license for himself or any other person. Here in this particular instance, he's done just that. Further, I think that it's clear under subsection 4 that he's committed a category E felony, but I would argue that he's probably also likely committed the category C felony under subsection 2A and B, with transferring and possessing that document with the intent to commit forgery. So based upon all that, based upon his non-technical violation here, based upon his overall rebuke of probation, as he's testified to right here in court, his probation should be revoked. We are asking that he gets the full credit for time served that he's owed, 342 days, with 23 days until he's parole eligible on his 12 to 120 month sentence in prison. If Your Honor has any further questions, I'd be happy to answer them. But my assessment of all this over the past 2 hearings is that the defendant he's essentially just admitted to everything, that yes, he was violating the law, and yes, he rebuked the probation grant that you gave him. It really leaves the court with no other option but to revoke his probation here today.
Mr. Gersten?
Thank you, Your Honor. I'm going to take the motion to impose sentence first and then move on to that. Just simply with the motion to impose, Your Honor, it was simply based on his non-signing of the document. I believe Mr. Blandino has at least made a case that he didn't understand what he was signing. Officer Chandler didn't have a problem with it. He said he's never happened before. He didn't push it up the line. There was no issue. Mr. Blandino, to the best of his ability, has been following his probation. He's behind a little bit on a couple of fees. He doesn't work. Completely understandable. I don't think that's a reason, again, to impose the sentence. I will say this. We were in the middle of actually preparing a motion to amend the judgment of conviction for Your Honor to consider when all of this happened. We are obviously holding off on that to see what happens here. But again, I believe that that is really a non-issue in this case. With regard to the second issue, which was the traffic stop, Your Honor, prior to Mr. Blandino testifying, I think Your Honor would agree, the state failed to prove that Mr. Blandino had presented this document or really done anything to pull him into this ambit of committing a felony by providing a false document. None of the officers could say that it was presented, that they saw it, that anything of that nature, again, before he testified. So the state's evidence, I believe, was lacking in that regard. Obviously, Mr. Blandino testified against advice, but again, that's his testimony, and I would submit that his testimony is just in question. Because again, what did he say that he did? At best, he has a novelty passport. And it's an Israelite passport. That's not a legitimate document, as anyone should know. Again,
I agree with that statement. I'm just not sure your client does.
Again, Your Honor, I can't help that. You know, I have to deal with what I have. But it's true. So for the officers to sit there and, again, after the car's been impounded, to find this document and then suddenly believe that this is a true document, Detective Shai was saying, you know, biblical verses. He called the State Department. I mean, they don't even know what this thing is. It's housed in a Mercedes-Benz cover. I mean, it's just not real. And I don't believe. And again, I would submit he never presented it for any benefit or anything of that matter. It's not real to begin with. So in that regard, I don't think he committed a felony, which would be required under the statute. Potentially, he potentially committed 2 misdemeanors: not having a driver's license, not having the car properly registered. Although, he claims to have a lifetime registration in Montana. So I'm not even sure that particular charge is viable. Potentially, he didn't have an actual driver's license under, if I may, Your Honor, under NRS 176A, I think it's 630. That's a technical violation. Graduated sanctions, he should be given 30 days. I believe he's been in already but 30 days. Even if Your Honor doesn't, I'm sorry, the technical violation, that was 176A.510. That's the technical. Your Honor, if you believe that Mr. Blandino actually did something wrong here. Because remember, as kooky as he is, he was simply trying to alert someone on the road that they had a light out. He did not do it in a proper or a safe manner, but really that's what he was trying to do. That's all he was trying to do. Under 176A.630, if you do find any of this, you have a series of 4 things that you yourself may impose. Starting with, under 1A, you can continue or revoke the probation or suspension of sentence. You can order him to a term of residential confinement, which is what, if you do choose to consider this a non-technical, we would ask that you do that. I mean, obviously, you could send him to regimental discipline, but I don't think he's built for that, if you will. So again, Your Honor, considering the totality of the circumstances of what we're talking about, he's kooky, but I'm not sure that he actually committed the felony, number one. I'm not sure there was enough evidence presented by the state to show that he committed the felony. Potentially a technical violation, understood. He really just needs to get back to his residence so he can take care of Evie, who you know is his ward, if you will. That's all he's simply trying to do. And with that, I'll submit.
Anything else?
So, counsel's arguments rest upon the document not being a good enough fake. That is not part of the statute here, Your Honor. That's not part of NRS 205.465. Here, defendant committed felony, undoubtedly. He committed felony while on probation 2 months after Your Honor gave him the opportunity for probation. The document here was used by the defendant for the purpose of establishing a false status, a false license. That's the felony. With that, I think that we go further into the same argument that he's used time and time again, that he needs to get home so that he can take care of Evie. Evie, Ms. Pendergraft, is currently in an assisted living facility. She's currently in a better place and with adequate care than she otherwise was and will be with him out. I'm not going to disclose which assisted living facility on the record, but that is what has occurred in the meantime. Further down that same line of argument, since it's been brought up, when the state previously came in and told Your Honor that we were going to be sending adult services and abuse and neglect potentially over to see Ms. Pendergraft when the defendant was in custody, defendant called Ms. Pendergraft and told her, and her son, and told her that they needed to post the property with no trespassing, no government official signs, because he doesn't trust the folks from adult services or the government at all to come in. Since that time, she's been in a much better situation. She's currently being looked after.
She has a son, did you say?
No, Mr. Blandino's son.
Oh, okay.
And so with that, Your Honor, it's clear, it's beyond what is required for the state's burden in a probation revocation hearing that the defendant has committed a felony here in this particular instance, well on probation, 2 months after this grant of probation. So we do ask that you impose the full sentence right now and just revoke his probation sentence, since it's the same probation sentence that he himself refused.
All right, anything else?
If I may, Your Honor,
you
I
may.
apologize.
You're
Just
fine.
As far as Evie's concerned, Your Honor, if you recall, at one of the prior hearings, Mr. Dickerson said, hey, we sent over, she's fine, adult services checked out. Either that day or the next, she had to go into an assisted living or hospital. So what Mr. Dickerson's comments about her well-being and whatnot really are suspect, because in court he said she's fine, and then she ended up the next day into a hospital and
Well,
whatnot.
she's like 96 or 97.
97.
Completely
Yeah.
understood, Your Honor. And again, I don't want this to become the focus of this
No,
hearing. It's not. It's a side piece, but just so Your Honor understands. Mr. Blandino is haranguing me, Your Honor, just to let you know that he believes he is entitled to have a jury determine a felony and he would object and request that. Again, that's his request. Other than that, I believe I can stand on the other statements I've made.
That's the remark regarding Ms. Pendergraft going to the hospital. In a series of calls that were made by the defendant after that hearing, the defendant spoke to Ms. Pendergraft while she was at home. He spoke to her, and he goes through, running through her health concerns with her. Says, how are you feeling?
Well, Your Honor, and
How are you feeling?
I have to object. He's testifying as to what Ms. Pendergraft said on a phone call. We're beyond
I'm
that.
not testifying, I'm arguing. I'm arguing in
This is
response to what he's
argument.
argued.
Go
But
ahead.
there was no evidence of
He
this.
asked her, how does she feel? She says, I feel good. My health is good. My knee kind of hurts. And then Mr. Blandino proceeds to convince her, during the same time that he's telling her he wants no trespassing signs up, he doesn't trust the government, he doesn't trust adult services to come in, that she needs to go to the hospital. And then she does. She goes to the hospital, and you know, it's a good thing she did, because now she is in an assisted living facility. But all of it seemed to be under the guise of Mr. Blandino trying to hide her from adult services.
Okay, at this time, the court's gonna reinstate you on probation with the added conditions that you do 30 days in the Clark County Detention Center. Upon being released, you'll be subject to intensive supervision pursuant to NRS 176A.440. You'll also be subject to the additional condition that you are not to drive a motor vehicle in the state of Nevada without a valid driver's license issued by the state of Nevada and the Department of Motor Vehicles. How much credit does he have towards that 30 days?
Yes.
I'm assuming,
At this time, he should have,
More than 30.
well, from when he was placed in custody.
approximately 45.
Okay, with 45 days credit for time served. When you get released, you need to report to probation within 24 hours so you can be placed on house arrest.
Judge,
you.
he ordered a
Stop.
release immediately. They take days to get that
Please
release.
sit down. Thank you, Your Honor.
Thank you.
Thanks, Judge.